We exist for two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is our mission. Today's hearing is an important one because the Consumer Financial Protection Bureau is intended to bring protections to the American people in and around financial products. We're here not to micromanage every aspect of that. The Financial Services Committee has a responsibility to look at the details of that. What we are here to do is our oversight role as to government organization, whether or not this agency is properly designed and prepared, whether the funding stream is appropriate and verifiable, whether it will be transparent, whether or not, as it's being organized from a 2,000-page document, whether the guidance has been sufficiently clear, and whether or not the American people can feel comfortable that what was envisioned in Dodd-Frank is in fact what they want. We appreciate Professor Warren's willingness to clear her schedule. Testifying for the second time before this committee, first time before the full committee, I know the American people want to know more about an agency that you've dedicated in some ways your whole life, but certainly the last year, to building up. The American people do not understand all the history that goes into your preparation for this, and I believe today is an opportunity for us all to get a better understanding of that. Additionally, the definition of consumer financial products protection is one that people don't understand. Quite frankly, it may apply to payday loans, but that wasn't the basis for Dodd-Frank. Dodd-Frank was about making sure that we never again had a meltdown because certain types of credit instruments were unsafe, unsound, poorly documented, and ultimately worth less than they were intended to. But it's clear today that we will be dealing with an agency that will be far larger. The budget for next year is estimated to be larger than the two largest consumer protection agencies presently in existence combined. It's a lot of money. Additionally, the authority of this agency is extremely broad. Today, we also will ask some important questions that this committee has been dedicated to, along with the Financial Services Committee, for some time. The Federal Reserve is not transparent. The Federal Reserve does resist any kind of congressional oversight and considers it unreasonable interference. There have been limited, and I repeat, very limited, ability to get transparency in some cases related to the financial bailout from the Federal Reserve. It is likely that without specific and documented ability to have guaranteed transparency and legitimate oversight, that this sub-agency, independent as it might be, but fully funded and accountable to the Federal Reserve, could well become an agency that, well intended, is not well understood or transparent to Congress or to the American people. These concerns and others will be voiced here today. We're delighted to have a witness who, more than anyone, absolutely understands the intention of her agency. Often, you have used the term cop on the beat. Oddly enough, we use it here too. Today, we will ask the questions that will include, does the cop on the beat have a district attorney overseeing the cop on the beat? Is there, in fact, a defense counsel available to check on the cop on the beat? Is there an independent judge of the cop on the beat? Is there, in fact, a court of appeals? And by the way, if I'm accused by the cop on the beat, can I get an attorney paid for by the State? These and other questions are important because we're not talking, in the case of your oversight, about only large international banks. We may be talking about a small organization formed for the purpose of one financial instrument, potentially finding that product in disfavor with the large banks who complain that that product is in some way deceptive. I have no problem with the idea that that will be looked into by your entity. I do have a question about whether or not that small company will have their day in court and their ability not to be in financial ruin if, in order to save their company, they must disagree with your determination. That and many other issues we will be concerned with. Lastly, there is a concept of individual liberty. One of the concerns that the Chair has, and I believe many members of the committee has, is at what point does the American people do the American people have a right to say, I want to be informed, I want to be protected by being informed, but quite frankly, I want something which you may not want me to have. In America, unless it is incredibly dangerous to others or may cause harm to society, generally we let people have what they want, even if we don't want them to have it. We could use many examples. I will simply quit with adult beverages. Under Dodd-Frank, the CFPB will have the power to regulate all consumer financial products and to prohibit the ones it deems unfair or abusive. Today, I hope we will be able to understand what under Dodd-Frank is the scope created by that language and others. I appreciate again your being here, and I yield to the ranking member for his opening statement.